have looked at the 14th Amendment and the concept of selective incorporation. And I hope that you have had an opportunity to do your writing explaining that the 14th Amendment gives the Supreme Court the right to tell states that certain laws are violations of fundamental rights. We talked about the cases of Gitlow versus New York and Neer versus Minnesota and Palco versus Connecticut to demonstrate how the Supreme Court went through and on a case-by-case basis decided which rights were fundamental. We also looked at a chart that gave us the case and the year when certain parts of the Bill of Rights were incorporated. The first concept under the Bill of Rights that was incorporated was freedom of speech. And that is the First Amendment. And so let's just look at the First Amendment. This is the full text of the First Amendment. Other than the Fifth Amendment, Fourth and Fifth Amendments are kind of long, but the rest of them are actually really short. And so let's read it together. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of the people peaceably to assemble and to petition the government for redress of grievances. We've been seeing a lot of that recently, haven't we? That right, the right not to be arrested if you are peaceably assembling, the right not to be arrested just because you're telling the government, I don't like what you just did, I would like for you to do something different, is guaranteed by the First Amendment. So on the PowerPoint, there is a table that is called a selected list of First Amendment protections. We are going to first talk about freedom of speech and freedom of press that are collectively called freedom of expression. So freedom of speech is defined as the ability to say almost anything without being punished unless what you say is obscene, it slanders someone, and we'll talk in depth about what slander means, or has a high probability of inciting others to make imminent lawless action. So that is the definition of speech. You can say almost anything and not be arrested. That doesn't mean that there won't be consequences, but not be arrested, not be in trouble with the government, with some exceptions. Freedom of press. You have the right to write. You have the freedom, we'll just say it that way, to write or publish almost anything. Same exceptions. You're not going to get any protection for writing something that is obscene. You're not going to have any protection for libeling, for saying something false about someone that harms their reputation. You're not going to be able to seriously endanger military action or national security, and you cannot incite imminent lawless action in your writing. But other than that, you are free to write or publish just about anything. Those are protections under the First Amendment. On another lecture, we will talk about the freedom of assembly and we will talk about the freedom of religion. But today, we are going to talk about the freedom of speech. So again, freedom of speech and freedom of the press or freedom of publication collectively are called freedom of expression. And this book has a tendency to go back and forth between speech and publication, speech and publication. I will, if I am alert enough, point out when we're talking about speech and when we're talking about publication. I'm hoping that this is not a concept that is going to give you any trouble. Speech is spoken, publication is written down and then given to other people to read. But freedom of expression is the most basic of democratic rights. Remember that freedom of speech and freedom of the press were the first two parts of the Bill of Rights that were incorporated. They were considered to be fundamental very early on. But prior to 1925, when we had the Gitlow versus New York case, John Adams convinced a Congress full of Federalists to pass the Sedition Act. Sedition Act of 1798. And John Adams, and just for reference, John Adams is Samuel Adams' cousin. John Adams was the person that had defended the soldiers that had killed 5 people in the Boston Massacre. John Adams had a big ego from all accounts and did not like being defied. If you have seen Hamilton, you will see that there was a documented conflict between Alexander Hamilton and John Adams, who were the same party, but they had a conflict. And for the most part, John Adams did not like being defied. So he got Congress to pass the Sedition Act. It said that any false, scandalous writing against the United States was banned. It was now illegal. You could be put in jail for saying something that was false or scandalous. And dozens of people were arrested for saying something or writing something that was against, really technically against John Adams. Thomas Jefferson, when he became the 3rd president of the United States, quickly got the Congress to let that expire. And then Thomas Jefferson began to pardon people that had been convicted under the Sedition Act. But just look at the wording. Just think about that. The First Amendment, which had been ratified, said that you cannot be punished for what you say. And here was a law that was punishing people for what they said. So it was on its face in conflict with the First Amendment, but we did not have time to litigate it. This is the point that I really want you to get, though. There are and have been throughout the years many instances where laws were passed either by the United States government and certainly eventually by state governments that clearly violated pieces of the Bill of Rights. But there was nothing to be done until number one, the court established the right of judicial review in the Marbury versus Madison case in 1801. And until that right was incorporated in the 14th Amendment in 1868 for states. Today, the freedom of expression, freedom of speech and press are vigorously protected by the courts. It is very difficult to get in trouble for what you say. And basically we say that if you can get in trouble for what you say, it either causes a danger or it is not protected. It is that type of speech that is not protected. None of the Bill of Rights are absolute. Even though they are written in absolute words, Congress shall make no law, is quite absolute. But immediately we see that lawmakers found that it was not absolute by passing laws that clearly abridged. And then we will see that sometimes even the court decided, well, in this case, it is okay to criminalize some type of freedom of expression. Now, that was especially true during wartime. So during World War I, Congress passed the Espionage Act. The Espionage Act said that you could be in trouble if you dissented, if you said something bad about the war effort. Now here again, Congress shall make no law abridging the freedom of speech or of the press. Here is a law that says that if you say something bad about the war effort, then you can be criminalized. And the United States government proceeded to convict thousands of Americans for saying negative things about the war. Well, it would seem like this would be a pretty open and shut case. In 1919, the case of Schenck versus United States made it to the United States court. Mr. Schenck, and just notice this is a case. This is a freedom of speech case. It is specifically addressing the Espionage Act. The Schenck versus United States case came to the United States Supreme Court. Seems like it would be really simple. Seems like the court would just simply say, yeah, that is a law that abridges the freedom of speech, but they did not. They upheld the Espionage Act. Now, what had Mr. Schenck done? Mr. Schenck had distributed leaflets that were urging people or men that were of draft age to refuse to be inducted into military service. He was arrested. He was charged with a violation. He was convicted for a violation of the Espionage Act. The court, and I believe Oliver Wendell Holmes wrote Oliver Wendell Holmes wrote that opinion. And he said, if there are certain times when speech cannot be protected, when what you say creates a clear and present danger. Now, they did note that this was wartime. And they said, when you are telling people not to show up for the draft, when we are needing as many people as we can get to participate in the war effort, that's dangerous. So, as an illustration of times when what you say can be dangerous, Oliver Wendell Holmes wrote, what if you shouted fire in a crowded theater. In that instance, he said, that speech would not be protected because the words themselves created a danger, a clear and present danger. So, what would happen if somebody was in a crowded theater? Hard for us to imagine that right now. And they shouted fire. Well, bedlam would come out. People would start running. People would start screaming. And people could actually be hurt. And it always reminds me of a story. So here we go with one of my stories. When I was a freshman in college, I went to a Greek show, a step show, in Denton at the Baby Dome. I don't know if the Baby Dome is still there, but it was a gym that was a complete dome. It was completely round. And I am a member of Delta Sigma Theta Sorority Incorporated. Ooh. And that is one of 4 sororities that are predominantly African American. But I had not, as a freshman, become a member, been initiated into the chapter. That happened in 1989 when I was a sophomore. But I went to go see Texas A&M perform, and I believe that only the Deltas is what we call ourselves, the Deltas. Kamala Harris is a member of Alpha Kappa Alpha, and they are called the AKAs, just for your edification. But I had gone to see the Texas A&M Deltas perform. So we're in this location, and probably 99% African Americans. And somebody runs in and yells, "He's got a gun." I remember it like it was yesterday. He's got a gun. And there was mass panic. People started running. People were screaming. I was up in the stands. I was away from the floor, but I just remember that my friend that I went with, started running down the stairs, and she fell. She slipped. And nobody would help her up. They were just running over her. So I'm pulling on her arm, and I pulled her out of the trampling people, and she had bruises all over her legs. All because a guy had said, "He's got a gun." So in that instance, just like in Justice Holmes's example, he created a clear and present danger by saying those words. Now, we found out later that there actually was one there with a gun. He was, however, outside. He was looking for his girlfriend, and he was quickly arrested. But mayhem had ensued, and people had gotten hurt because of the announcement, the words that the person had said. So that is another example of how words can create a danger. So the common law, the judge-made law on the issue of freedom of speech remained that you will not have protection if the words that you say create a clear and present danger. Under that law, 11 members of the Communist Party were prosecuted, and it made it illegal to advocate forceful overthrow of the United States government. So under the clear and present danger test, there were several people whose speech was restricted, despite the fact that the First Amendment says no law. So that was really the test until 1969. We had a case in Ohio. Mr. Brandenburg, who was a member of the Ku Klux Klan, had a rally. He invited the press to come. He made a speech. He made this speech on television, and these are the words that got him in trouble. We're not a revengeant organization. But if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it is possible that there might have to be some revengeance taken. So this was well after judicial review had been established. This was well after the 14th Amendment had been ratified. In 1969, Ohio had a law that was called the Criminal Syndicalism Act. And what it said was that you could be in trouble, charged with, and perhaps convicted of advocacy of overthrow of the government. Now that seems pretty safe, because there had been many instances where advocacy of overthrow of the government had been upheld on the federal level. So Ohio probably felt pretty safe with their criminal syndicalism law. Well, Mr. Brandenburg appealed this conviction. And the case got to the Supreme Court in 1969. I am not sure what month in 1969 and whether or not Earl Warren was still there. But the court basically changed the test. So where before the test had been clear and present danger, the test was switched. And so they basically said that you are going to have to, when you are writing your laws, distinguish between mere advocacy, where we possibly might have to, and actual incitement. Come on, let's go do it now. They found that Ohio's law was unconstitutional, and Mr. Brandenburg's conviction was overturned. The final thing that they did in the Brandenburg versus Ohio case was give us brand new test, brand new common law. Common law, again, is judge-made law. They changed the test from clear and present danger to direct incitement. So since 1969, the test for whether or not your particular law is a violation is the direct incitement test. And so the direct incitement test says that your law cannot punish advocacy of illegal action unless that advocacy is very clear and is inciting immediate action, imminent lawless action, and is likely to produce such action. I'm going to say it one more time. It has to advocate illegal action. It has to directly incite or produce imminent lawless action, and it has to be likely to incite or produce such action. So really, unless Mr. Brandenburg had said, my truck is out there, y'all hop on the back, we're going to Washington, D.C. right now to kill the president and all as many members of Congress as we can, that's direct incitement. Just saying we might have to, we should, is not enough. So it is, and has been since 1969, very difficult to punish speech, or at least to have a law that punishes speech. Let's talk about hate speech. So the case is RAV versus City of St. Paul. Anytime you see that, anytime you see initials in the title of a case, that is because the person that has been charged criminally is a minor. And so that we don't say the full name or even the last name of a minor, even if they are being charged as an adult. So RAV was a 16-year-old, and he was white. A black family had moved into St. Paul, Minnesota. And St. Paul had an ordinance, the city of St. Paul had an ordinance that made it a crime to engage in speech or action that is likely to arouse anger, alarm, or resentment on the basis of race, color, creed, religion, or gender. There had been a series of such laws passed. Most of them were aimed at hate groups that were saying and doing really ugly things. And so they were aimed at curbing this speech. So in this instance, it was symbolic. What RAV did was went to the home of the black family, and he burned a cross on their front lawn. And now I hope that you know, I don't have access to my favorite video. It is a History Channel production called The Secret History of the Ku Klux Klan. But I hope that you know that when a cross is burned in your yard or in your vicinity, it actually means something, and not I'm on fire for Jesus. It means the Ku Klux Klan has their eye on you, and you need to stop something you're doing, or we're coming to get you. So it is not only ugly and not only a sign that the Ku Klux Klan has been there, it's also a threat. So clearly, when this young man made the decision to do this was a violation of St. Paul's ordinance. And when he was discovered, he was arrested and he was charged with the violation of the ordinance because of the nature of the message that it sent. That case got to the Supreme Court in 1992. And in 1992, in a 5-4 decision, now there's 9 justices normally, 9 justices on the Supreme Court. And when you see a 5-4 decision, usually that means that they were fighting, that it was very close. They usually come out at the end of the session, and they were really divided on how to come down on this. But nonetheless, the common law that was established was that you cannot silence speech just because you don't like what people are saying based on the content. So there are really ugly things that people say. especially when they get in groups. Boy, have we not seen some recently. In Charlottesville, Virginia, a couple of years ago, at rallies all around the United States, and none of that is, according to the Supreme Court, a violation of the law, even though it is super offensive to some people. Our Constitution, the Supreme Court says, protects it. Now, there are some places, like colleges and universities, that have banned hate speech, and the Supreme Court has basically said it is fine because you don't have to be at that university. You don't have to be at that school. So when you decide that you are going to go to a certain school, you agree to rules. And so it is fine and not perfectly legal to have hate speech bans on college campuses. Question: does Tarrant County College have a hate speech ban in their student handbook? Go look it up. You will find that they actually do not. They actually do not. And there are a lot of reasons for that. They tried and were actually sued. The Smith versus Tarrant County case. And so now all that it reads is that you cannot, if somebody is invited to campus, you cannot heckle them or say ugly things to someone that is a guest on campus. What about Westboro Baptist Church? They have not recruited a lot of new members, and the children of the members of this church, who are pretty much related, have a tendency to speak out against them. But Westboro Baptist Church is an organization that specifically, number one, believes that the reason that the United States experiences death in wars, and really any bad thing, but specifically death in wars, is because God is angry at the United States for being so permissive about homosexuality. So it's very specific, very interesting, and very specific doctrine. The way that they express themselves is that they go to funerals of men and women killed in combat. So imagine that you are the spouse of someone that was killed, or the parent of someone that was killed, or the sibling of someone that was killed. You are trying to have a ceremony, and outside there are people screaming, hollering, singing, and holding signs like the ones that we see. You can imagine that hurts, especially at that time. And it is especially, in my opinion, cruel. And so over and over again, you would see these people outside of the funerals, and eventually, of course, they were sued. And it was a parent of a gentleman that had been killed in combat, and he just said that they had caused emotional distress. They had been really close to the building. that he was not able to mourn in peace. And what they were saying was particularly offensive. That case wound its way through the court system, finally made it to the Supreme Court, and the Supreme Court said, even this ugly speech is protected. And so Westboro Baptist Church won. And let's just, I'm going to go back to the RAV case. Remember that the young man had actually gone onto someone's property and burned a cross in their front yard. Certainly, he could face charges, not for the message, but for what? Criminal trespass, for arson, for criminal mischief. And so the moment that you go from saying something to action, then there's not protection for the action. And then the question becomes, can the action be enhanced because of who you aimed it at? Those are called hate crimes. So all we are talking about is the message, is the speech, and that is protected. So just like in the RAB case, the whole concept of symbolic speech, we consider symbolic speech where you don't say words, but you send a message. It is protected as political speech, the highest of the types of speech. Your political opinion is protected by the First Amendment. So, way back in 1931, there was the case of Stromberg versus California. Stromberg versus California. And this was a gentleman that ran a communist youth camp. That sounds like a party. And at the youth camp, he displayed a red flag. And California at the time had a law that made it illegal to display a red flag because that was a symbol of opposition to the United States government. At a time when communism, being a member of the Communist Party and espousing communist ideas, was becoming more and more of a red flag in the United States. But even in 1931, the Supreme Court said, yeah, that's protected speech. And they overturned his conviction and told California that their law was unconstitutional. In 1969, we had a really big symbolic speech case, and it was called Texas versus Johnson. If I am not mistaken, that this was an outgrowth of the Democratic Convention in 1968. And Mr. Johnson had burned a flag outside of the convention. Now, if we look at this picture, this young lady seems to have a lot to say about the United States, a lot to say about George W. Bush. I'm assuming it is because of the ears. And just notice that she spelled out Bush and put a swastika on the S. So, not very happy with the United States government under George Bush or George Bush himself. With this body burning, and the body is burning the American flag. This personally drives me up a pole. Just coming from a family of military men. I think I told y'all my brother went to West Point. My dad was a lieutenant colonel. My nephew is a second lieutenant in the Army. I I was a Girl Scout. We learned flag etiquette. The only time you burn the flag is if the flag is in ill repair. This literally drives me up a pole. I cannot stand it. But she is saying something, and she does have a message. At the time when Mr. Johnson burned the flag, Texas had a law that made it illegal to burn a flag. Burn the Texas flag or the United States flag. And he was convicted of and charged and convicted with a violation of Texas's law. He appealed his conviction. It made it to the court in 1969, and the court said, this is symbolic speech. We've already talked about this. And even flag burning, I understand that it evokes certain emotions, but even that, and it was a 5-4 decision, even that is speech. Political speech, protected speech. A few years ago in Texas, a group had submitted a request to add a specialty plate to the offerings of the state of Texas. You know, you can get plates that for organizations, I can get a Delta Sigma Theta plate for, and so they had submitted a request to add a specialty plate that had an image of the Confederate flag. And the state of Texas, surprisingly, actually said, no, we are not going to allow you to have an image of a Confederate flag with the official name of the state of Texas on it. That is too much. That's state sponsored. And the group sued and said that was freedom of speech. And they said, the court said, if the state does not want to be associated with that, you cannot force the state to basically endorse that image if they don't want to. So the state of Texas won in that particular case, and it wasn't being criminalized. They were just denying them access, I guess.